Harvard Law School Seminar Room, 1961. 15 law students and one observer, Malcolm X. The white professor is teaching 14th Amendment doctrine. Malcolm sits quietly taking notes for the first hour. Then the professor makes a claim about Section 1's original intent. Malcolm raises his hand, politely disagrees. The professor is not accustomed to being contradicted, especially not by someone who isn't even a law student. He tells Malcolm that constitutional interpretation requires rigorous legal training, that Malcolm's view, while interesting, doesn't align with established doctrine, that perhaps Malcolm should read more Supreme Court cases before challenging professors. Malcolm opens his notebook, asks if he can read something. What Malcolm reads shocks everyone in the room. But before we discover what Malcolm read from his notebook, and how it exposed the professor's error in front of his own students, if you appreciate stories about how academic authority gets challenged by genuine scholarship, how credentials don't guarantee knowledge, how someone dismissed as an outsider can know more than the expert, please subscribe. Hit that like button if you believe truth matters more than titles. These stories remind us that real expertise comes from study and understanding, not from position and prestige. Now let's find out exactly what Malcolm had written in that notebook. Harvard Law School, Cambridge, Massachusetts. The most prestigious law school in America, the institution that trains Supreme Court justices, senators, corporate lawyers, legal scholars, the place where constitutional law is not just studied but shaped, where doctrine is debated and refined, where the next generation of legal minds is formed. The building is Langdell Hall, classical architecture, high ceilings, wood paneling, portraits of distinguished professors and alumni lining the walls, the weight of history and prestige in every detail. This is not just a school, it's an institution, a symbol of legal authority and intellectual excellence. The seminar room is on the third floor, room 312, a small classroom designed for advanced seminars. 15 students maximum. A large oak table dominates the center. Students sit around it. The professor stands at the head, behind him a blackboard covered with constitutional amendments, case names, dates, the detritus of legal analysis. It's Tuesday afternoon, 2 o'clock, Constitutional Law Seminar, the 14th Amendment, a graduate-level course. Students are second and third-year law students, the best and brightest. They've already survived the first-year gauntlet, already proven themselves intellectually, already beaten out thousands of applicants to get here. They're on track to become federal judges, law professors, Supreme Court clerks. The professor is Dr. Thomas Whitmore, 63 years old, teaching at Harvard for 32 years, published author. His textbook on the 14th Amendment is used in law schools across the country. He's argued cases before the Supreme Court, clerked for a Supreme Court justice in his youth. His credentials are impeccable, his authority unquestioned. When he speaks about constitutional law, people listen. When he writes about the 14th Amendment, scholars cite him. Malcolm X is not supposed to be here. He's not a student, not a professor, not affiliated with Harvard. He's an observer, a guest. He was invited by one of the law students, a young black man named Robert Chen, who attends Malcolm's speeches. Robert thinks Malcolm would appreciate seeing constitutional law taught at the highest level, thinks Malcolm would benefit from exposure to rigorous legal analysis. Malcolm accepted the invitation out of curiosity, wants to see how Harvard teaches constitutional interpretation. Malcolm arrives 15 minutes early, finds room 312, knocks. Professor Whitmore opens the door. Malcolm introduces himself, explains he's Robert's guest. Professor Whitmore looks skeptical, but allows it. Says Malcolm can observe from the chair by the window, must remain silent, must not interrupt or participate. This is a seminar for law students, not a public lecture. Malcolm agrees, thanks the professor, takes his seat. Students arrive, settle around the table, open laptops and notebooks, review readings from the previous week, exchange greetings with Professor Whitmore, acknowledge Malcolm with brief glances. Most seem indifferent to his presence. One or two look curious. Robert gives Malcolm a slight nod. Malcolm nods back. Professor Whitmore begins precisely at 2 o'clock. He lectures from notes he's refined over decades. His delivery is polished, authoritative. He assumes knowledge, assumes students have done the reading, assumes they understand basic constitutional structure. This is graduate-level work. No hand-holding, just sophisticated analysis of complex doctrine. Today's topic is Section 1 of the 14th Amendment. The most important section. The section that guarantees equal protection, due process, privileges, and immunities. The section that fundamentally changed American constitutional law. The section that the Supreme Court has interpreted and reinterpreted for 150 years. Professor Whitmore discusses the original intent behind Section 1, what the framers meant when they drafted it in 1866, what they intended to accomplish, how they understood key terms like equal protection and due process. This is contested territory. Scholars disagree, but Professor Whitmore presents his interpretation as settled doctrine, as the mainstream understanding, as what any sophisticated legal mind would conclude. Malcolm sits by the window, taking notes, writing down everything Professor Whitmore says, not just the main points, everything, direct quotes, citations, arguments. Malcolm's handwriting is neat, methodical. He's done this for years, copied entire pages from books to improve his vocabulary and retention, developed the discipline to transcribe lectures accurately while processing their meaning. 1 hour into the seminar, Professor Whitmore makes a specific claim about Section 1's original intent. He says the framers intended equal protection to apply only to legal rights, not social rights. That the framers drew a clear distinction. Legal rights, like the right to own property, make contracts, sue in court, those were protected. But social rights, like the right to attend integrated schools, sit anywhere on a train, enter any establishment, those were not protected. The framers, according to Professor Whitmore, never intended Section 1 to require social equality, only legal equality. This interpretation has significant implications. If Professor Whitmore is right, then school segregation doesn't violate the 14th Amendment. Separate but equal is constitutional. Brown v. Board of Education was wrongly decided. This is not a fringe view. This is what many segregationists argue. What Southern senators claim. What conservative legal scholars write. Malcolm raises his hand, politely, not aggressively, just a calm hand raised at shoulder height. Professor Whitmore pauses, looks at Malcolm, seems momentarily confused, then remembers. The observer. The guest. What does he want? Professor Whitmore acknowledges Malcolm with a slight nod. Malcolm speaks respectfully, thanks the professor for allowing him to observe, says the lecture has been fascinating, then politely disagrees with the professor's characterization of Section 1's original intent, says the historical record suggests the framers actually intended equal protection to apply to both legal and social rights, that they specifically rejected proposals to limit it to legal rights only. The room goes silent. Students stop typing, look up from their laptops, look at Malcolm, then at Professor Whitmore. Someone just contradicted Professor Thomas Whitmore. The Professor Thomas Whitmore, the man who wrote the textbook, who argued before the Supreme Court, who shapes constitutional doctrine. Professor Whitmore's expression hardens. He's not accustomed to being contradicted, especially not by observers, especially not by someone who isn't even a law student, who never attended law school, who has no legal training or credentials, who's sitting in on one seminar as a courtesy. His tone shifts, still controlled but colder, more condescending. He says Malcolm's view is interesting, says he appreciates Malcolm's engagement with the material, but says constitutional interpretation requires rigorous legal training, requires understanding of jurisprudence, precedent, doctrine. Says Malcolm's interpretation, while perhaps emotionally appealing, doesn't align with established scholarly consensus. Says perhaps Malcolm should read more Supreme Court cases before challenging professors who've dedicated their careers to studying these questions. The students watch this exchange carefully. They sense the tension, the dismissal, the assertion of authority. This is a teaching moment for them, not just about constitutional law, about intellectual hierarchy, about who gets to speak with authority and who doesn't. Malcolm doesn't argue, doesn't get defensive, doesn't challenge the professor's credentials, just says he has read quite a few Supreme Court cases. Has also read the congressional debates from 1866, when the 14th Amendment was drafted. Has studied the speeches of the framers, has examined their writings, has traced how their understanding of equal protection evolved during the drafting process. Professor Whitmore waves this away, says anyone can read historical sources, says interpretation requires training, says knowing how to read legal materials critically is what separates law students from laypeople, says Malcolm's confidence in his interpretation reveals his lack of understanding of how constitutional analysis actually works. Then Professor Whitmore returns to his lecture, continues explaining why Section 1 was limited to legal rights. Such cases, quotes scholars, builds his argument systematically. The students take notes. Malcolm continues writing in his notebook. 20 minutes later, Professor Whitmore finishes his explanation, opens the floor for questions. Several students raise hands, ask clarifying questions about specific cases, about how this interpretation relates to civil rights legislation, about whether this affects affirmative action doctrine. Professor Whitmore answers each question. His expertise is evident, his command of detail impressive. This is what Harvard trains lawyers to do: master doctrine, navigate complexity, argue with precision. Malcolm raises his hand again. Professor Whitmore sees him, hesitates, then calls on him. Malcolm asks if he can read something from his notebook, something relevant to the discussion about Section 1's original intent. Professor Whitmore says he'd rather stick to questions about the material covered, but Malcolm says this is directly relevant. It's from the congressional debate, from Senator Jacob Howard's speech introducing the 14th Amendment to the Senate in 1866. Professor Whitmore pauses. Senator Howard's speech is important. It's one of the key historical sources for understanding the amendment's purpose. Professor Whitmore has read it, has cited it in his own writing. He's curious what Malcolm thinks is relevant, says Malcolm can read it, briefly. Malcolm opens his notebook, finds the page reads clearly, precisely, quotes Senator Howard explaining that Section 1 abolishes all class legislation and does away with injustice of subjecting one caste of persons to a code not applicable to another, that it protects the rights of every human being regardless of color, that it establishes equality before the law, that it prohibits discrimination in civil rights and immunities. Then Malcolm reads the specific passage that matters. Senator Howard explicitly stating that Section 1 gives Black Americans the same rights to full and equal benefit of all laws for security of person and property as white citizens possess, not just legal rights. All laws, all benefits. Full equality, no distinction between legal and social rights. The room is silent. Malcolm continues, reads another passage from Representative John Bingham, the primary author of Section 1. Bingham stating that the amendment is designed to protect all persons in their civil rights, that it forbids any state from discriminating between citizens in the rights secured by the Constitution, that it makes the Bill of Rights applicable to the states, that it fundamentally changes the relationship between citizens and government. Malcolm finishes reading, closes his notebook, looks at Professor Whitmore, says respectfully that the historical record seems to show the framers intended broad application of equal protection, not a narrow legal rights interpretation, that they specifically wanted to eliminate all forms of discrimination, legal and social, that they understood Section 1 as a revolutionary change in American law. Professor Whitmore's face has changed color. He knows these passages, has read them, but he's interpreted them differently, emphasized different aspects, focused on other statements by other framers that support his position. That's how constitutional scholarship works. Selective emphasis, strategic interpretation. But Malcolm just quoted the two most important framers, directly contradicting the interpretation. Professor Whitmore spent an hour defending. The students look at their professor, waiting for his response, waiting to see how he handles this challenge. This is not a typical seminar exchange. This is someone without legal credentials, using primary sources to contradict someone with impeccable credentials. Professor Whitmore clears his throat, says Malcolm has identified important passages, says they're relevant, but says constitutional interpretation isn't just about what individual framers said, it's about overall legislative intent, the compromise process, political context, says his interpretation remains valid. Malcolm nods, doesn't push further, but the damage is done. The students heard Malcolm quote the framers directly, heard him demonstrate that Professor Whitmore's interpretation presented as scholarly consensus is contested. One student raises her hand, asks Professor Whitmore about the specific passages Malcolm quoted, asks how he reconciles them with his interpretation. Professor Whitmore gives a complex answer involving legislative compromise and subsequent judicial interpretation. But the answer is defensive now, not authoritative. He's having to explain away primary sources that contradict his position. Another student asks Malcolm where he found these quotes. Malcolm says he read them in the Congressional Globe, the official record of congressional debates from 1866. Says he spent several weeks in a library copying passages from the debates. Says he wanted to understand what the framers actually said, not just what scholars say they said. The student asks which library. Malcolm says the New York Public Library. Explains he doesn't have access to law libraries, but the public library has the Congressional Globe on microfilm. Says he read all the debates about the 14th Amendment, all the speeches, all the committee reports, took extensive notes, built his own understanding from primary sources. Professor Whitmore interrupts. Says they need to move on. Says this has been an interesting digression, but they have material to cover. Returns to his lecture. But the authority in his voice is diminished. The students keep glancing at Malcolm, keep thinking about what just happened. After the seminar ends, several students approach Malcolm, want to see his notebook. Malcolm shows them pages of handwritten transcriptions from the 1866 debates, organized by speaker, cross-referenced by topic, the work of someone who taught himself constitutional history through primary sources. Robert thanks Malcolm for coming. Says Malcolm just challenged Professor Whitmore more effectively than any law student has. Malcolm says he wasn't trying to challenge anyone, just trying to understand what the framers actually intended. One student asks if Malcolm has considered law school. Malcolm smiles, says law school is not in his plans, says he's more interested in using law to fight injustice than becoming a lawyer. Professor Whitmore remains in the classroom. Packing his notes, he overhears students praising Malcolm's research. His authority has been undermined by a self-taught observer who spent weeks reading microfilm in a public library. Malcolm leaves, thanks Professor Whitmore. The professor nods curtly, watches Malcolm walk out with students still asking him questions. That evening, Professor Whitmore goes to his office, pulls out his copies of the congressional debates, finds the passages Malcolm quoted, realizes Malcolm was accurate, word for word, realizes his own interpretation has downplayed these passages. Over the following weeks, Professor Whitmore revises his lecture notes. Not dramatically, but adjusting. Acknowledging more complexity in the historical record, Malcolm's intervention changed how he teaches Section 1, word spreads through Harvard Law School. Some faculty dismiss it. Others are intrigued. Several students start doing their own primary source research. Malcolm's example showed them that sometimes the best understanding comes from going directly to the sources. Malcolm never returns to Harvard, never pursues the academic respect that moment could have opened. He doesn't need Harvard's validation. Constitutional law is a tool. Understanding the 14th Amendment helps him argue for equal protection. That's the goal. Years later, after Malcolm's assassination, Professor Whitmore is asked about him. He says Malcolm X was one of the most rigorously prepared observers he ever allowed in his seminar. Says that afternoon challenged Whitmore's thinking about how we construct historical narratives, about whose interpretations we trust. If this story made you think about how authority operates in intellectual spaces, how credentials can substitute for actual knowledge, how people without formal training can sometimes see more clearly than experts, then subscribe. Hit that like button if you believe truth should matter more than pedigree. Consider who you trust based on titles versus based on evidence. Consider what we lose when we dismiss voices without credentials. Consider how many Malcolm X's have been silenced in academic spaces because they didn't have the right degree.